Hi, Benjamin Jaffe here with Eskew Law. We're kind of going through some common questions or popular searches online today. One of the questions we often get, or is kind of a popular question, is what does beyond a reasonable doubt mean? That's a very tough question, actually. If you've ever been in a jury trial, you've ever been a juror, the judge, when they start talking about the idea of beyond a reasonable doubt, they kind of acknowledge it's a kind of an abstract concept. Beyond reasonable doubt generally means, and I think there's pretty much across the board agreement, that it's a very high standard. So there can't be any real reasonable doubt, any reasonable thought that this didn't occur is sort of the idea. And so if there is some doubt, or if there's a real possibility that something didn't happen, and it's not some imagined or silly possibility, that would not, be sufficient to be beyond reasonable doubt. And so I sometimes use an example of Invasion of the Body Snatchers. If that's your idea that this person didn't do it, is, well, maybe aliens came and switched the bodies. That's not a reasonable reason to think someone, didn't do what they're accused of. But if there's a real question, like, hey, maybe you got the wrong guy, the description here is pretty off, or, something along those lines, or it's very likely we're hearing evidence, contrary to what this is being presented by the state, it's sort of your personal choice as to what isn't reasonable. But like I said, there's general agreement that beyond reasonable doubt is an extremely high standard. Some people like to try to put percentages on it. It's never really appropriate, but I think there's general agreement. We're talking about, as close to, 100% as you can get without being 100%. So, does that mean 90% to some people, 95%? Like I said, it's a very high standard. It's a standard where you essentially know you're not making a mistake. And when I say no, you aren't left with doubt as a juror. And I tell jurors, if you go home and you lay your head on the pillow and you go, man, but what if this? There's a reason you're thinking that, and that's a reasonable thing, and it's not a silly thing necessarily. So you can't have those doubts. You have to be convinced that you're doing the right thing in order to find someone guilty beyond a reasonable doubt. So it is a standard used in trial as the standard you have to reach in order to convict someone. So it's really related to that idea of conviction. It's not they must be innocent or anything like that. It's just, are they absolutely guilty beyond any doubt, any reasonable doubt, I'm sorry. If you think they may have done it, that's not enough. If you think they could have done it, certainly not enough. Even if you think they probably did it, and judges will say that to jurors, it'll be part of, the instructions that are received is probably isn't even enough. And so you have to basically do away with any reasonable possibility that the person didn't do what they're accused of.